Hi, I'm Sue Odom. I'm a tax and employee benefits lawyer here at Nexsen Pruet. ERISA litigation is on the rise, but employers shouldn't fear litigation. Instead, they should embrace it because it gives us the tools that we need to design and administer our employee benefit programs. The ERISA litigation craze has been class action lawsuits alleging breach of fiduciary duty against administrative firms and investment firms. These cases target these firms probably because of their deep pockets, with allegations over excessive fees and expenses that are charged. In many cases, the cases are dismissed with the courts finding that the parties sued are not fiduciaries under ERISA. But it will be interesting to see what happens in the future as the Department of Labor is struggling over defining who is a fiduciary. We also have had a number of cases in the health plan context. For example, there's been a case in New York involving Dave & Buster's. The allegation in this case is that the employer violated ERISA Section 510 by intentionally interfering with employee benefit rights. The case involved Dave & Buster's, as I indicated, who purposely, allegedly, reduced the hours of some workers so that they did not have mandated Affordable Care Act health insurance coverage. It will be interesting to see what happens in that case as well, and we'll keep our eye on that one. The case was allowed to move forward. In the United States Supreme Court, we also had some activity involving subrogation. It is a very interesting case that involved a drunk driver who was involved in a car accident with a participant. After the participant received reimbursement from the plan for $120,000 of medical expenses and signed a reimbursement agreement, the health plan tried to sue the participant against his general assets to recover the $120,000 that the plan had spent. This case ultimately concludes that the health plan does not have a claim against the participant's general assets under equity, finding that that's a legal claim, not an equitable claim. Because in this case, there were questions about whether the assets were traceable to specific items of property. If the participant had spent the money on untraceable items such as services, spa treatments, or things of that sort, travel, food, then there would be no identifiable property against which the employer could recover. So the lesson from that case is employers and health plans need to act quickly and be very involved in the litigation and settlement negotiations in order to have a chance of recovering their out-of-pocket costs from the health plan. Finally, we had a case from the 11th Circuit, unpublished opinion involving Verizon, where the court again upheld an anti-assignment clause included in the health plan. In that case, the plan essentially said that participants are not allowed to assign their claims to other healthcare providers who then could bring the claims on their behalf. And the court upheld that, which is perhaps a guiding principle that employers should consider adding those provisions to their plans if they're finding that in many cases it's providers who are challenging denials from health plans on the basis of reasonableness or other plan terms. Last, we had a case involving a wellness program. In that case, we had an interesting new twist. Instead of focusing on whether the wellness program was voluntary in nature or not, that wellness program was in fact mandatory in nature. The employer conditioned health insurance coverage on the employee's completion of a health risk assessment and biometric screening. The court upheld the wellness program against an EEOC challenge, finding that there was a specific exception in the EEOC, American with Disabilities Act rules, that allowed the employer to do exactly what it did. So this may be a complete change in the direction for where we're going with wellness programs and a step in the right direction from the standpoint of a lot of employers. If you are interested in learning more about that latter case, there's another video on that subject as well as other publications on my website. Thank you.